Hello, family and friends. I'm going to share some very important information with you. If you've ever been to family court, if you've ever had engagement with a CPS, as a matter of fact, if you've ever been in a court at all, if you've ever engaged with a police officer, an attorney, a social worker, a hospital worker, this is pertaining to you. And I was actually going to hold back and not share what I've already known for quite some time. But I really wanted first to have solid evidence in order to support what I was saying so that it couldn't be taken back or removed. What you're about to learn here is quite disgusting. And that's why I decided that instead of holding back, I'm going to give you the meat and the potatoes first. And we're going to talk later about what we can do about it, how it affects you and your family. Even if you haven't been involved in the court system yet, there's a 90% chance that you are going to get involved in the court when you get a divorce. So if you are married or thinking about a divorce, this is something that you really need to take into consideration, because when you do these things, when you walk into those courtrooms, you are putting your children in very grave danger. And this is going to show you how that danger occurs, why it occurs, and I'm going to explain to you what it's worth. And I hope that you will download this video. Make sure that when you download it, you share it with every person, every family member, everyone you know, because this has got to be the most disgusting, heartbreaking, horrible, horrendous thing ever known to mankind. And this is all not from the people you think are heroes, helpers, justice providers, looking at you equally to provide an equal remedy to your situation. That's not what this is. This is the truth. This is the truth behind the robe, the truth behind the badge, and how they have absolutely no intent on helping you, your family, no intent on protecting you or your family ever, in any circumstance, ever. And I'm going to explain that to you, but we're going to read this article first, because this is what I've been looking for so that I could share this information with you and not have to worry about not having enough evidence to support it. So unfortunately, like I said, I have been knowing about this for some time, but it took a little while to link up what exactly they were using it for. This is going to tell you about, basically, it's backing up Edward Snowden in what he had found. If you're not familiar with Edward Snowden, he had to leave the country because he had found that the government agency, NSA, was spying on all Americans. And for the most part, most Americans say, it's okay, I have nothing to hide. This is something you need to understand if you think you have nothing to hide. It isn't about having anything to hide. It's about probing your personal mind to create something that you may have to hide if it was spun and portrayed to be something that it really wasn't. So about the not having something to hide, that's not what you should be concerned about, friends. What you need to be concerned about is how information collected about you that you don't know exists, that you have no opportunity to review, that you have no opportunity to dispute, exists in a data center where every single one of these so-called helpful, friendly agents of yours have very sadistic and dark plans for that information. Simple, small, embarrassing moments of your life will be spun around when they want something from you to make you look like you're crazy, to make you look like you have a problem, so that they can project and deflect all of the things they want to do to you. And if you don't see through that from what I'm about to share, then you must be one of them, or sign up and get a robe. sign up and get a badge, because I have not ever made any comments about judges or officers to this extent until now, because this is grotesque. And I hope that this message gets downloaded as many times as humanly possible. And you make sure that it gets sent to everybody that you ever meet, and you talk about it loud so that people understand. Snowden was exiled into Russia because he blew the whistle on the collective information of the NSA over the public, over the people. And they're calling it espionage simply because he told the truth. And there are others just like him that are going through that scenario right now because they don't want you to know this information. And you have to question, if they're so innocent and they don't have bad intentions, why do they try so hard to conceal this? How come they haven't notified you of this? And why would they ruin a man's life for simply telling the truth? Snowden found that they were spying on us, and now I'm about to tell you why and what it's used for real. So what we're looking at here is the Journal of American Academy of Psychiatry and the Law. Psychiatry and the law, unbeknownst to you, goes hand in hand. What I have found is that the judges, the prosecuting attorney, and the defense attorney all work together in order to assess your mental capabilities based on all the information collected about you over your life. So if you had possibly been a child with social behavioral issues at school, doping you out didn't work, if you have children in school right now having social behavioral issues, this is prejudicial to them for the rest of their life. So maybe you don't have anything to hide, but perhaps you have something to protect. Perhaps you don't want your child to be prejudiced in a way that when he is approached by officers in the future, they will be able to excuse the fact that they use excessive force on him based on his social misbehavioral patterns. So this is where we begin our little journey through the psycho bullshit of these people. I can't call it anything else but what it is, and that's just the truth. So what we have here, and it doesn't matter if you're in a court for CPS or criminal court or traffic court even, the courts you're in are general provisional courts. What that means is they are conducting risk management services and bypassing the Article 3 constitutional courts that you believe exist. The courts you see on TV where a man goes to trial, he has a fair and meaningful hearing, he has evidence, and that evidence has to equate to being so convincing that beyond a reasonable doubt, he would have to be found guilty. That would be an appropriate criminal court, like you see on TV. But for those of you who haven't been in a court, this is not at all what goes on inside those rooms. I personally have audited and analyzed several cases involving several different matters, such as CPS, family court, traffic court, and criminal court. And in those audits conducted, I have never found anything that was even up to the clear and convincing standard that would make me agree with the judicial opinions of all the cases I've reviewed. And I am not alone. There are many people out there who can tell you the same exact scenarios. So keep that in mind and keep an open mind. The reason I'm sharing this with you openly, even though I was going to hold it back, is because reading this I realize I can't let you go through this. I can't let my brothers and sisters in God go through this. This is wrong. And I hope that you receive this message with the utmost love, because it is only my desire to protect all of you from any further harm. I want to empower you to protect your children from the harm they intend to perpetrate on them. And I want you to start respecting your privacy in a way you've never respected it before, because this is very, very important to you. When you are dealing with any of the agents I named before, they take little notes inside their little computers, and those notes are not factual based notes. Those notes are opinions. Perhaps they don't like you. Perhaps they think that you are somehow lower life form than they are. Remember who you're dealing with. These people have obtained their professional degrees and have a certain self-righteous vision of themselves, thinking that they are of a higher knowledgeable form of person than everyone else. So when they look at you, you may look to be to them as disgusting. Maybe you look to them as being totally outrageous, antisocial, socially defective, and perhaps they believe a social cleansing is necessary in order to rid this world of people with those defects. I don't know, but what I do know is that about 100% of the time, most court cases don't end up in favor of the defendant. They don't end up in favor of the party without an attorney. They never do. And that's important to understand. A friend of mine actually did an accounting to see how many pro se litigants actually won their cases, and the answer is none. 100% of the time, or no, I'm sorry, it was 98. I take it back. I think it was 98% of the time. If a person walks into a courtroom representing themselves, they lose. That's not on accident. Not 98%, certainly isn't. And this is exactly why right here. So we'll read a little bit and I'll go through what I've learned and what I know about this system. And hopefully it's clear and concise to a point that you can comprehend and discern with what I'm telling you. And I'm hoping that in showing you this, it will ignite the very significant and detrimental details that I believe you gotta get a fire after reading this. You just have to. So here we go. The Anglo-American legal system regularly looks to forensic practitioners to provide expert testimony on the likelihood that an individual will pose a risk to others. Experts may be asked to provide risk assessments in the criminal court with reference to a reoffending risk against either the general public or an identifiable victim, or in the civil courts, usually with reference to named individuals. In the family court, where the welfare of the child is paramount, mothers, fathers, and any other people with access to children may be the subject of a risk assessment. Such assessments are one element of the evidence that the courts must consider in deciding the welfare of the child. There is now a considerable body of empirical evidence about risk and factors that increase it, including individual mental states and a variety of disorders. The business of predicting risk, or risk assessment, has grown exponentially in the past 2 decades, but there is considerable debate about the accuracy of the prediction. Experts are required to perform specialist assessments to a high professional standard with respect for the principles of ethics, especially the prevention of harm. Such advances in empirical understanding of risk have led to considerable professional concern about risk assessments that are ethically unacceptable because they are carried out inappropriately or negligently. Negligence in this context may include ignoring relevant actuarial or clinical information or including irrelevant facts, both of which might substantially alter the outcome with harmful effects on the evaluee. That's you. Experts are required to show that they have proficiency in performing risk assessment. For example, being trained in the use of specific tools such as the psychopathy checklist, revised PCLR, or the Historical Clinical Risk Management Scale, HCR20. The use of risk assessment in the family courts reflects the societal desire to be risk-free or at least risk-aware. The stakes are particularly high in relation to children, where a vulnerable child may face immediate risk at the hands of a parent, or face the risk of being separated from a non-dangerous parent if the assessment is wrong. And I'm here to tell you, friends, it's always wrong, and that's on purpose. The reason it is always wrong is because they don't weigh the scale based on which parent is of higher or lower risk. They don't weigh the scale based on what they really believe is the best for the child. They weigh the scale on which way the pendulum is swinging into the most profitable circumstance. That's how they weigh the scale. If they don't find you to be mentally inept, if they don't find you to have some sort of defect, they don't get paid. So why would they let you walk out of that room without making an assessment that you have some sort of mental defect? It would not be lucrative. They'd be wasting their time, their effort, and their money. And they would also be losing credit from the university who pays them to collect this data, because that credit helps them to increase the benefit of the municipal pension fund. So all of those municipal pension funds have levels, 1, 2, 3, 4. And in those levels, depending on how much of this you've done to children, you will have a better pension fund to look forward to through the municipality that was paid for by the public citizenry of the university. Anyone who's been in family court knows, now at least you know for sure, why everything went so horribly wrong and why you left there feeling dazed and confused and lost. So merely knowing about the risk is not enough. There must also be a strategy to prevent that risk. And that's where it gets juicy. Limitations of risk assessment in relation to family courts and child protection. The bulk of risk research in psychology and psychiatry has focused on the contribution of mental disorders to the increase in risk. There is much less empirical research into psychological or psychiatric risk factors that directly or indirectly influence the risk of serious harm to a child. Prediction of future risk relies heavily on past events. Yeah, where do you think they got the information to find out about your past events? Your doctors, your teachers, police officers, social workers, psychiatrists. They all share the information in network systems that provide you with insurance that you likely don't even know about. And so that's why we have these risk prevention tools. Prediction of future risk relies heavily on past events. If we are to project the future based on the past, we need not only good data about the past, but also some confidence that the future will be like the past, or some basis for figuring out how it will be different. The need to predict brings us to the question for the present discussion: what are minimally acceptable as good data, and how confident do we have to be to talk about future risk? It is generally believed that the more accurate the data on which risk is based, the more accurate the prediction. The more accurate predictions of future risk are derived from actuarial data based on statistical analysis of group behavior. This is important. Group behavior, statistical analysis of group behavior. That could be based on your race. That could be based on your financial standing. That could be based on many different things of a class of persons, increasing your risk to be determined to be an abuser, a criminal, a social misfit. And that is very important, because that really means that if other people that are of like kind badly behave on a regular basis, this decreases your points, your good points, and increases your bad points for something somebody else is doing. That's a fair and meaningful hearing here in the United States, friends. Fair and meaningful. Yeah. So, based on statistical analysis of group behavior, as opposed to individual clinical data, single clinician assessing and summarizing the risk factors. Usually, concerns about risk start from allegations of behavior, speech, or expressed intentions that are perceived as a threat of violence? Well, let's talk about that. Allegations of behavior. Just because someone doesn't like how you act, that means you're of high risk. The way you talk elevates the level of risk that they might think you have against hurting someone, in particular your children. Now that's evidence, like, definitely agree with you guys. If somebody has a speech pattern that may not be proper or elegant, or if their behavior is more defensive in nature, or if you can analyze how they express themselves as being bad intent because you know them for 10 minutes, is that about right? 10 minutes, and you can determine in those 10 minutes, maybe see them, once a month in court, and you can determine all of that to equate to them being a high risk. Now that's some serious evidence, folks. You better be careful. That's convincing for sure. This coming from people who commit crimes and corruption, extortion. We should definitely trust their observations and allegations of your expression. Yeah, sounds about right. All right, so good quality risk assessment and prediction rely on what are categorized as dynamic factors that change such a mental state or intoxication, or historical factors such as a criminal record and age. The key point here is that historical factors are fixed and cannot change. The establishment of facts, therefore, has tremendous relevance to risk assessment because of its impact on scoring of actual risk measures. For example, a clinician may be asked to perform a risk assessment on an individual who has no established history of violence or arrest. There may be allegations against an evaluee, and these may be serious, but there is currently no way for forensic experts to utilize risk assessment tools based on allegations. In fact, any clinician who does so would be going beyond his expertise, misusing the actuarial tool in a potentially negligent way, and acting unethically. Anybody been through this? Sounding familiar? Negligence, unethical use of these opinionated observations by people who don't have any clue as to who you really are other than what they're reviewing on a computer screen. And like this says, you may not have a criminal record, and yet they're going to assess your mental capabilities anyway, because they must have psychic powers. I don't know, maybe they can see through your brain, who knows? But simply based on the fact that I don't like you, I might not care for your personality. Sometimes I've met people where in the beginning their personalities have come off to be aggressive or hyper, and I may have not really liked them at first, and some of them became my best friends after getting to know them that way. So how do we determine that on meeting someone for a few minutes, we can allege that they have a potential risk of being violent simply because we don't like their first impression behavior? And that's what these tools are used for. So if you tell a cop no, and he has an ego, if you exercise your rights and say, I'd like to remain silent, and he don't like that because of his ego, what do you think his assessment about you is going to look like when it goes through the system and into the courtroom? And this is what the judge sees. This is what they analyze before your case is ever heard. So if you have an egotistical cop, I mean, we all know that's so very rare. It doesn't happen very often. So yeah, maybe you don't have anything to worry about. Go get a badge, go get a robe, participate. This tool, how did I find it? Because it's a mirror image of Hitler's consensus kind of manipulation. This is where it comes from. If you like it, Hitler's your guy. He's the one who created it. Enjoy. So, anyways, going beyond this expertise, misusing the actuarial tool in a potentially negligent way. This is from 2011, friends. So they knew in 2011 that people courts, judges, cops were using this tool negligently and unethically. And we know this today for anyone who's ever stepped foot in a courtroom. You know there's a lot of unethical analyses going on in your cases. Courts have been traditionally content to accept individual clinical judgment as a basis for risk assessment. Now, however, it is acknowledged that in some circumstances, clinical judgment alone, i.e. an individual assessment of the evidence, is no better than a flip of the coin. Mulvey and Litz argued persuasively that it is quite plausible that unstructured clinical judgments are not made consistently and rationally. Know what I just said? A rational judgment by a cop? I'd like to see when that happened. Scheme and colleagues have found that assessments made solely on clinical experience often overestimate risk, i.e. have false positive rates. Again, this is from 2011, and I'm here to tell you many children have been removed from their families based off of these false positive rates. Deliberately so, because again, if these false positive rates don't exist, they don't get paid. They don't make money. They don't get grants. They don't get none of it. The compilation in these scenarios is that where there are disputed facts, judges are asked to make a finding of fact that determines history for the purposes of future risk assessment. Does that sound like a judge to you? Does that sound like a fair, meaningful, unbiased, and impartial hearing to you? If a judge is looking at your history and the notes of people who've come into communications with you based off of power-hungry ideals, how are you getting a fair and meaningful hearing in a fair and meaningful way? How are you supposed to be able to combat the preconceived notion of the so-called judge after he's reviewed that information as the matter at hand? Now imagine you could have been 21 years old and got caught drunk driving. You could have been 22 years old and maybe got into a bar brawl. And that's what he sees. Maybe you're 50 now and you possibly exercised your rights and a cop didn't like it, put you in the jail, you got in front of the judge, and all he can see is that you had a DUI and a violent history for that bar brawl. Why should he ever believe anything you say? Why should he give you any kind of impartial judgment at all? That's a farce. It can't happen. It's an impossibility. So what happens is the chief judge of your court conducts this risk assessment the moment your case hits the floor. So while you're waiting that 30 days to go to your hearing, an undertaking has occurred by the chief judge to determine your risk factors and to determine what grants you might qualify for, or your children in the case of family court. And they estimate which direction do we want to go based on how much money we'll make. If we can qualify them for the most grants possible by saying their kids are neglected and abused, by saying they need psychiatric services and mediation, this would be the most lucrative direction we could take. So he sends that little message over to the judge that you're going to see in 30 days so that he can also assess which direction would be most lucrative. We can offer you some psychological services, some correctional services, and some family services because the children will qualify in addition to you. Double whammy, yay us. An expert in the English family court may find himself asked to provide an assessment of risk where the only facts are those determined by a single judge as being 51% likely to have occurred, and therefore are true for the purpose of determining risk to a child and related welfare concern. Experts are asked to accept the accuracy of the judge's findings, even though an assessment on the standard of balance of probabilities closely resembles the type of unstructured one-off single clinical assessment that is now deemed to be poor practice in clinical forensic settings. The evidentiary standard of the facts determined by a single judge and the weight and morality of the application of facts determined in the risk assessments, on which so much depends for a family, is the central theme of this essay. Judicial approaches in England and Wales to risk facts and evidence in the family court. Actuarially violence risk assessments have established that, generally speaking, if there is evidence of harm done in the past, then it must follow, if nothing is done, that there is a risk of harm in the future. By the same argument, however, the possibility that there has been harm in the past does not necessarily establish the risk of harm in the future. The strongest statement that can be made is that what may have happened in the past means that there may be a risk of the same thing happening in the future, although the size of the risk is unknown. However, courts that deal with child welfare have adopted a much more cautious approach. For example, in regard B, heard by the House of Lords in 2008, the court said that a prediction of future harm could be based on findings of actual fact made on the balance of probability. In this case, in a much quoted judgment, the then Baroness Brenda Hale said that in the English legal system, if a judge found it more likely than not that something did take place, then it did take place. The occurrence of harm is enough for a child to be removed from his parents if the parents are suspected of perpetration, even if no perpetrator can be identified. So we can take your children and remove them, even when we can't say you're a perpetrator. Why would we want to do that? Maybe, and this is just a thought, maybe because when a child is found to be dependent, this gives them the opportunity to say that the child is in need of a guardian. And then when they are able to give the child a guardian, the guardian can make medical and financial decisions for the child. They can then qualify the child for grant money that the mom and dad would never have known existed or been able to qualify them for in order to get these people paid. Maybe that's a possibility. Or maybe it's possible that the opportunity, if someone's not a perpetrator and we're not sure, well, we can force them to take a bunch of other lucrative services within our network, such as psychological services, drug services, all kinds of goodies for them in our bag. And we'll make money that way too. Ooh, you have 3 or 4 kids? That is a lucrative finding, wouldn't it be? In determining whether harm has actually been done by someone and then finding that someone, the English family courts have long debated whether there should be a sliding scale of certitude based on the likelihood of occurrence of the alleged event. In regards to a sexual abuse case, Lord Nichols of Birkenhead said that the standard of proof may vary with the gravity of the misconduct alleged or even the seriousness of the consequences for the person concerned. However, subsequent judgments at appellate levels have established as settled law that there is but one civil standard of proof: balance of probability, or more likely than not, roughly thought to be over just 50%, or a flip of a coin. So if we think there's just a possibility that you might maybe possibly abuse your kid, we will take that kid and we will put that kid in a foster care system, and that child will every day cry and miss his mother and his father and his old family life that he will never see or never know again, because it was 50% likely that you may possibly be some kind of abuser. But since we're not sure, we'll put him in foster care. But we know for a fact at least 100 children per year are going to die there, be raped there, molested, abused, tortured, beaten, stabbed. but that's less risky for the child. That's definitely a good idea if we're not sure whether or not a parent is an actual abuser. That's a standard of evidence if I've ever heard one. This standard is applied when establishing the threshold for making a care order under 31(9) or the welfare considerations under 1 of the Children's Act of 1989. Neither the seriousness of the allegations nor the seriousness of the consequences should make any difference in the standard of proof. Oh my God, I'm sorry. So if you neglect your child, or if you straight out assault your child, we don't want to take that into consideration. Both children should equally be ripped away from their parent and equally be placed into a foster system where they will be neglected and abused. That's the better standard. That's the better idea. That's definitely more important to the child's health and well-being than to flip the coin in the other direction of the parent. Wow. And they say that we have a mental defect? I call bullshit. Who in the hell reads this, knows this, understands the total disgusting and irrational decision-making tool? This is hideous. This is just grotesque. Anyways, it makes intuitive sense to think that the more serious the allegation, the less likely that the event occurred, and hence the stronger the evidence needed before the court concludes that the allegation is established on the balance of probability. Ungode Thomas expressed this neatly in Regarding Delo's Will Trust. The more serious the allegation, the more cogent it is, I can't speak, sorry. The more cogent is the evidence required to overcome the unlikelihood of what is alleged and thus to prove it. Such an approach is consistent with the criminological data which show that serious physical violence is a comparatively rare form of criminal behavior. Is that so, you little geniuses? With all the crappy science you've pulled from these machines, from these bullshitting actors who have entered false and fictitious data, and you think you have some sort of grip on what is a rare form of criminal behavior versus what is a more probable form of criminal behavior? The data you've collected is junk. You don't even have standing to make that decision or that conclusion. You can't conclude this because every single one of your actors have been found to be somehow criminal anyway. If you look at the statistics on their own website, you can see for yourself how many times false arrests are made, how many false imprisonments have occurred, how many false shootings have happened to citizens, how many false accusations against parents have led to a child being harmed inside of a juvenile center or inside of a foster family home. And you think the science you collected makes you somehow superior in knowledge? I think it makes you retarded. Any child could figure out the equation in this. The degree of certitude about facts is therefore different for criminal and civil family cases, with the former requiring evidence beyond a reasonable doubt and the latter considering only which side has the preponderance of evidence, i.e., whether the proposition is 51% or more likely to be true. The ethics-related argument seems to be that there should be a very high standard of proof before a person is found guilty of a criminal act, but a much lower one for determining a history of possibly criminal harm to a child. A single family court judge can, in effect, arrive at a legal opinion that one or both parents have harmed their child based solely on reading of the material before him. Okay. Wow. You ever got to see that material, friends? Has any single person in the history of the court system since you've been alive, have any one of you ever been able to read the material he's reading? As a matter of fact, 100% of you didn't even know it existed. Does he hide it because he has good intentions? Does he conceal it because he's a good guy who's looking out for you? Do most good people conceal these things? Probably not, but you have nothing to hide. From an empirical risk assessment point of view, this is morally unjustifiable. Takes a genius to figure that out. And literally, this guy's a genius. An expert who carried out a risk assessment using this method would rightly be criticized. Nah, not at all. It might be argued that judges have a public mandate to make these rulings that experts do not have. Judges are aware of this concern, however, as demonstrated somewhat inconsistently by Lady Hale in regarding B, she quotes Butler's Floss in another case regarding M and R. The fact that there might have been harm in the past does not establish the risk of harm in the future. Although this is not what the medical view is from psychiatry, the very highest it can be put is that what might possibly have happened in the past means that there may possibly be a risk of the same thing happening in the future. Section 1.3e, however, does not deal with what might possibly have happened or what future risk there may possibly be. It speaks in terms of what has happened or what is at risk of happening. Yeah, did we catch that? He just repeated himself or whatever. Thus, what the court must do when the matter is an issue is to decide whether the evidence establishes the harm or the risk of harm. She went further. To our minds, there can be only one answer to this question, namely the same answer as given by the majority in regarding H. The court must reach a conclusion based on facts, not on suspicion or mere doubts. Lady Hale is invoking a proper respect for doubt and uncertainty in the finding of facts. Lessons from quantum mechanics suggest that there is a degree of uncertainty in the measurement of individual atoms. Equally, individual humans differ from groups. Statistics for groups work well for car accident insurance, but not for determinations that have massive human consequences. Oh my goodness. And it literally took a genius to say this out loud. And even still, again, this is from 2011, this genius who came up with that conclusion obviously isn't being heard. Some human phenomena do not obey the deterministic Newtonian rules, but resemble chaotic systems where tiny random changes have large, unpredictable effects on the other systems. And they want to get rid of you if you're that guy. The chaotic systems inside of your soul, or the free spirit is what I would call it, is completely and totally socially unacceptable. Be a robot like the rest. Family disputes and risk. The situation in the family courts is further complicated by the nature of the dispute facts before them. The most common scenario would be one in which a mother accuses an ex-partner of domestic violence or abuse of their children in a custody dispute. Fathers rarely make equivalent allegations of serious violence. Instead, they may claim that the mother is mentally unstable or disordered, has an addiction problem, or is in some way neglectful of the children. Oh man, that sounds about right, man. Come on, back it up, back it up. The current adversarial system in England and Wales encourages each parent, based on descriptions of alleged past behavior, to imagine how the other parent will behave in the future. In effect, these are also informal risk assessments based on a parent's fears and concerns. Well, let's look at that, you geniuses. So one parent is saying the man is violent, and the other parent is saying the woman is neglectful and crazy and has a drug problem. Let's rely upon those allegations to determine if we should take those children away from both. Just based on those allegations, my friends, you put your children in the utmost danger. Because if both of these kinds of parents are found to be unfit because one has been determined to be violent and the other one determined to be a drug addict, neglectful parent, then your children will go to a neglectful system where abuse that you've never seen or heard of happens to them. So if you think your neglectful mama sucks, or if you think that that guy sucks so much you want to pretend he's violent, consider this. Really, are both of you in a position in which you can determine that one of you is going to hurt your child more than the strangers that child's about to go to? Let's not do it, huh? How about we don't falsely accuse each other of crimes against our children when we're angry, because the punishment of those children will be far more severe than the suffrage you may endure by having to communicate with your partner. Now, I understand there are truly violent people out there, and you want to do your best to prevent your children from being in their grip and, whatever, man and woman alike. But if there's no violence, if there really isn't a problem with you thinking that something physically bad is going to happen to your child and you just don't like the other parent, leave these things off the table, please. Please. This will also prejudice your child's future. Your bad behavior is basically going to be in the system so that they can see that your child likely will grow up to be like you. And then that child is going to have a very difficult social standing and status in this particular world, because Auschwitz is for real. And you don't want your kid to be the one in the chamber, you know what I'm saying? So let's refrain, shall we, from pointing fingers at each other. I know it's hard. Sometimes you don't like your significant other or your former significant other and you just want them to stay away. I get it. But not to this extent, not by putting your child at risk to enter into a arena of abuse, segregation, separation, heartache, loss. Like this it's just not worth it. The current adversarial system in England and Wales encourages each parent, based on descriptions of alleged past behavior, to imagine how the other parent will behave in the future. In effect, these are also informal risk assessments based on the parent's fears and concerns. Research on the hidden nature of much domestic and sexual violence toward women has encouraged courts to take seriously allegations of violence made by mothers, even when there is no corroborative evidence. In the United Kingdom, there are pressure and protest groups that have argued that to do so is sexist and therefore unjust. It can be difficult for a man to demonstrate that he presents no risk to others, and current risk assessment tools can only make findings of low risk, not no risk. Women's capacity for antisocial attitudes and behavior is often minimized or overlooked when compared with that of men. Sounds like a good system, huh, guys? You like it? Sounds like something you have nothing to hide and want to participate in willingly? Consider the following imaginary case. A couple separate and their child is left with the husband's family. The mother has a history of mental illness. The father has been the subject of investigation for alleged fraud, but has no convictions for any crime. After several years, the mother returns and seeks sole custody of the child. As part of her case for custody, she alleges that she was the victim of repeated severe violence, both physical and sexual, which the father denies. She also claims that she has received death threats from both her family and her ex-husband, and consequently is in police protection with a new identity. There is a lengthy fact-finding hearing in which a single judge finds that all the mother's allegations are fact on the balance of probability. Would you like to be accused of all of that because it's probable? Come on, that's too much. An expert is jointly instructed by all parties, including welfare services, to assess the father and the paternal grandmother, to provide an opinion as to the risk that the father poses to the mother, his child, and women in general. Yeah, guys, come on. Honest to goodness. Let's be real. Again, I know there are men who are violent and women who experience violence in their home, and I am not talking about you. But I also know that some women, in order to get their way in the courtroom, will cry wolf. And a man who is innocent will be put through hell based on a false allegation like that. If we're determining probability and not evidence, not a good idea. How should an expert approach this question morally and legally? Well, how about we leave the morals out the door and you just make a legal determination? How about that? Based in evidence. Wow. Could that possibly be what a court is for? Oh my goodness. No, not here, not in this country. In legal terms, the father is now established as a violent rapist. And that severely will bias the opinion of the judge, wouldn't it? Would that possibly mean that this father would not get an impartial, fair, and meaningful hearing? Probably. But there is no evidence beyond the materials before the judge to which the expert does not have full access. Ethically, the expert is at risk if he attempts to make a prediction based on poor quality data, including the use of actuarial risk prediction instruments without a proper history. In any event, the use of these instruments is problematic as the expert is transferring probability data from a group to an individual in the group. For example, an individual score of 22 on the VRAG, Violent Risk Assessment Guide, indicates that a person with the father's characteristics is part of a group with a, say, 35% chance of recidivism over a 5-year period. What the VRAG does not and cannot tell us is whether this individual will be in the 35% who will reoffend or one of the 65% who will not. Such statistical uncertainty may work in therapeutic settings where the treating doctor can discuss with the patient this fallacy of prediction based on a group model, and the patient can choose whether to accept the remedial advice. In short, the patient is allowed to take a chance. In forensic assessment of risk, the evaluee is not allowed to take a chance or even express a choice. Let's talk about that. No choice to determine whether or not you are going to receive psychological services. No choice whether or not someone's going to probe your brain and try to absorb all your secrets, with no evidence to support the reason why you should even be psychologically attacked in such a way. Based on a prediction, on a probability, we're going to force you to be probed, prodded, based on a probability. No evidence. That sounds very eerily similar to another country. Not the land of the free country, but another country. Someone who did similar things when they forced people to do socially acceptable behaviors with, I think they were called Nazis. That's right, Project Paperclip. If you haven't seen it, look it up. I forgot. These professionals, these scientists who conduct these sort of experiments came from there. What a coincidence. Wonder if we have any of those in our group at the colleges that are local. Perhaps they had children that have the same visual ideas they do in communism. I don't know. Sounds about right. Stedman and colleagues in 1994 and Hebron in 1997 argued that psychiatrists and psychologists have a responsibility to assess the violence risk of their patients or clients, to define the context, when and under which conditions, and to monitor changes in those conditions. The relevant question has now become, how can we do justice to this heavy burden we carry? And how to do it in a morally defensible way. Oh, they're so tired, friends, of stealing children for risk management. So tiresome collecting all that money to earn, what, $280,000 a year? So tiresome, this burdensome work, to have a mansion and all these fancy cars and everything in the world to give to my own children. It's so burdensome to make these decisions. Yeah, right. One-off clinical risk assessments are thought to be unreliable because of the biases of clinicians. No shit. And the unreliable weight they may give to certain factors. That was what I said. As opposed to the more accurate weight given by actuarial data. Judges who establish facts in cases involving disputed violence are effectively making risk assessments and may be equally prone to bias. Is that what I said? I'm not a professional, okay? I'm not a part of the paperclip project. I'm not one of the scientists who came here for this. And I can clearly see that on the couple of years I've been studying this nonsense. And still, again, this is from 2011, friends. This is from 2011. And I guess this guy he must have been shot down on his opinion, I guess. It wasn't going to help them make money, so they could not give this opinion and use it. Anyways, and it may be equally prone to bias and prejudice. In one case known to me, the judge included a relative's moral compass, or lack thereof, as relevant to balance of probabilities of whether violence had occurred between a couple. Then there is the problem of identifying an individual who may have done nothing from a pool of perpetrators. Barron's Hale said, day after day, up and down in the country, on issues large and small, judges are making their minds whom to believe. They are guided by many things, including the inherent probabilities, any contemporaneous documentation or records, any circumstantial evidence tending to support one account rather than the other, and their overall impression of the characters and motivations of the witnesses. She acknowledges that the task is a difficult one, but then this task is one that the judges are paid to do to the best of their abilities. In the family court, if a judge gets his risk assessment wrong, not only will a child potentially be placed with the wrong caregiver, he will be separated from a really loving one. Oh yeah, that's what happens most of the time. To whom he may have a strong attachment. Disruptions of childhood attachments have negative long-term effects on children's psychological development and are just as damaging as any form of abuse. So, when the judges get it wrong, it's excusable, friends. Who cares? The only person not allowed to abuse a child is you. Anyone else can do whatever they want to that child. There's no protections from the person, from the actors, from the officials. There are no protections under the Juvenile Act or anywhere else that I can find. If anyone other than a natural parent is accused of abuse, based on probability and the flip of a coin, the judges, the police, CPS agents, guardian ad litems can all abuse your kid. Who cares, right? Who cares? Don't pay attention to that. Go back, sit down, watch some TV. Disruptions of childhood attachments have negative long-term effects on children's psychological development and are just as damaging as any form of abuse. Indeed, Main and Hesse argued that child abuse is damaging precisely because it is the child's attachment to the abuser that is damaged. In the hypothetical case described above, any morally defensible forensic risk assessment of the father has to take account not only of the findings of fact by the judge made on a mere balance of probability, but also of the more incontrovertible lack of contemporaneousness evidence, such as medical records that document violence or police logs or criminal records, or else it remains unsatisfactory. How should the court view risk? Should it stick by its own findings and any sense of risk that comes from them? Or should the court respect the results obtained by a professional who has carried out a rigorous risk assessment based on all the data there are, including the judge's finding of fact? Is fact determined on balance of probability more probative in risk assessment than absence of evidence that is uncontested? Clinicians often overstate risk for their own safety. Should judges do the same? A prediction of future harm can be based on findings of actual fact made on the balance of probabilities. But the absence of good quality facts means that a good quality risk assessment cannot be performed. The secret services of both the United States and the United Kingdom struggled with this problem after the attack on the World Trade Center in 2001, where an absence of facts combined with great distress and fear resulted in high levels of anxiety for those services and politicians alike. Oh, poor service providers and politicians. They must have been so distraught. More distraught than human trafficking children based on a probability assessment tool that gives them a lot of money in their pocket to determine that a child is neglected. Yeah, I'm sure they're real broken up. It is understandable that courts, like any other social group, cannot tolerate anxiety, but this anxiety should not justify injustice. The English courts appear to have had their final say on fact-finding and risk, even though it could appear illogical and unjust. The potentially unfair shift of balance is justified by the duty of the family court first and foremost to protect children. But remember, they don't say this in its entirety. Their only duty, their only care is to protect children from you. They do not protect children from anybody else. Not a foster parent, not a juvenile facility, not a CPS lying worker, not a cop. The only time they wish to protect a child is from you. And the reason is because if the cop abuses the child, if the foster care parent abuses the child, if the CPS agent abuses the child, there's no money in that. Why would we want to go after them? Or why would we want to evaluate the risk imposed upon child being exposed to harm and assess the agency itself? Because they know what it would look like. The risk factor to be putting these children into these places would be far, far greater than the 51% toss of the coin for the parent to keep the kid, even if they are accused of neglect. Makes me angry, guys. Sorry, I know I get emotional on this one, but this is something, like I said, it's very close to my heart. The difficulty is that it seems inevitable that they will make findings of fact and balance of probabilities that are tantamount to criminal convictions, and then use those facts to make risk assessments about future harm. I end this piece by giving the full quotation from Lady Hale and RB in regarding B. In this country, we do not require documentary proof. We rely heavily on oral evidence, especially from those who were present when the alleged events took place. Day after day, up and down in the country, on issues large and small, judges are making up their minds whom to believe. They are guided by many things, including the inherent probabilities, any contemporaneous documentation or records, any circumstantial evidence tending to support one account rather than the other, and their overall impression of the characters and motivations of the witnesses. The task is a difficult one. It must be performed without prejudice and preconceived ideas. Okay, really? It must be? Then you need to remove all of the data that the judge is looking at, not allow him to see it at all, not tell him anything about the people or the case, and then he can go ahead and perform his duties without prejudice and without preconceived ideas. As long as his ears are being filled with all these different people's opinions and receiving data about you that could be 20 years old, he will never be able to perform his duty without prejudice, and he will never let you stand before him without a preconceived notion of who you are. Impossible. And it doesn't take a genius to figure that out. But it is the task which we are paid to perform to the best of our ability. Yeah, well, I call bullshit. Judges do not have to give reasons for their rulings, which is a real pain in the ass. That's why we didn't know these systems existed. They don't have to give reasons. They don't have to tell you that they are secretly viewing personal private information about you. They don't have to tell you who and where that information came from. They don't have to tell you that the attorney, your attorney, the defense attorney, and the prosecuting attorney are both conducting mental evaluations about you that they will share. Yeah, the guy you think your friend, the guy you think you hired, all political if you win. That dude is actually evaluating you too. So they don't have to give reasons for their rulings because they know that if they did, it would cause for an outrage. people would not agree with their findings. That's not an honest friend. That's not someone with good intent. So stop thinking that these people are somehow on your side or somehow good guys, and start thinking more about how your neighbor is probably being put through hell if they're in one of those rooms. Start thinking that your neighbor, when they speak, are telling you the truth, and that they have tendency to be more honest and more tendency to be honest than any one of these black-robed weirdos. They are virtually unimpeachable in this regard, except by challenge and appeal courts. And that's a lie, friends. For anyone who thinks you can just impeach or challenge an appeal court, that is yet another concealment. That is yet another false sort of, what do you call that? A false projection. To actually be able to impeach a judge is something extraordinarily rare. But even then, you're just going to get another one of him in his place, just like him, with the same preconceived notions, the same data, the same everything, with the same paycheck and the same pay provider. So it doesn't really matter if he's impeached or not anyway. But once you try to get into the court of appeal, your child has already grown. That's how long it takes. So if you want to appeal this decision, you have to first wait for a final decision to be made. That could take anywhere from like 12 to 15 months. Your child is growing. It's a child. You're missing out on all that time. And now once you hit the appellate court floor, they will make sure you cannot appeal. They will do everything in their power to make sure you don't have that appeal go through. And it is very, very difficult, complex, and you can't read the nonsense, and it is confusing. And all the while, it's not you that's suffering the most. It's the baby that's sitting somewhere wondering where his mommy is, wondering where his daddy is, wondering why he's in a place with a bunch of strangers who have lice, who have bad intentions. Why are we okay with that? It just boggles my mind. Because the lower courts hear and see the evidence, appeal courts are generally loath to interfere with their findings. Forensic psychiatrists are servants of the court. Actually, I prefer to call myself a forensicist. Like my American colleagues, I serve the court with publicly stated principles of respect for persons, honesty, justice, and social responsibility. Whatever my personal prejudices or beliefs might be, when I am in that role of forensicist, I abandon my personal beliefs and strive to serve my master with regard to nothing but those 4 pillars. 4 pillars? Oh, well, this is in England. Maybe they have 4 pillars, but that's odd. And abandon your personal beliefs to serve your master. You got a master? Who is he? If you're abandoning your personal beliefs, it seems a bit contradictory to strive to serve a master. I don't know who that master is. Kind of scary to think. That just says to me you contradicted yourself. You can't abandon your personal beliefs because you're striving to serve your master when you're making these decisions. Hope it's not Satan, because your kids are screwed if this guy's on the case. It is no use to me or anyone when I am in court to say that truth is but one more piece of information to manipulate to achieve the greater goal of obtaining the desired verdict. Courts may be more interested in credibility than truth per se, but I don't see it that way. I trust that none of my forensic colleagues do either. Well, if that don't say it all, and these people think that you're the one who has a defect, and oh my God, I don't know, it's kind of crazy. Anyways, I needed to share this with you because, like I said, I have been researching this analytical predictive tool thing for quite some time. I knew that CPS used it. I knew that the court was using a form of it, but I wasn't sure what exactly or how exactly they were using it yet, until like only a few weeks ago, actually. And now that I have the solid evidence to support it, I hope that in sharing this information with you, you will be able to further understand why these accusations are being made against you. And I hope that for the parents out there who feel that some sort of stigma is placed on them when their children are removed fraudulently, remember, just print this out and you show people it's not that you did anything, it's a flip of the coin that decided that your children should go into an abusive environment. Just a flip of a coin. Doesn't mean you're guilty. Doesn't mean you're innocent. Doesn't mean there was evidence. A flip of the coin decided your children's fate. I hope people really take that to heart. And I hope that, again, you download this, you get this article, you download it into a computer, because I promise you it will disappear. And I wish you all the best. I hope that we can use some of this information and expose this and get some of these babies to come back home to a place where they're loved. And I look forward to some more videos. I'm going to get deeper into detail in regards to how they use these tools, in regards to who uses them, in regards to how they get paid and by whom. So this is just the tip of the iceberg, friends. And in case something, you know, like if you don't hear anything in videos from me on this topic in the future, at least you have a base. At least you have something to look for. And this is hugely important. This is a violation of our privacy rights on so many levels. This is so many horrible things I could go on about all the different laws that this is in violation of, but this has been long enough video. So this is a good start. And I hope that you all start doing your research really hard on this. There is a way to get the information that the court is looking at. You can, in fact, get those assessments. You're supposed to be able to, but I'm sure they're not going to just hand it over. And they're not trying to ruin their little bread and butter. They like those fancy cars and those big houses. They like their kids being safe. Must be nice, huh? Have a good night.